Hello everyone, I'm Maratrika Bhaumik and welcome to LiveLaw. In an important decision for rights of women who remarry, the Supreme Court on Thursday observed that the mother, being the natural guardian of the child after the demise of the father, has the right to decide the surname, and accordingly underscored that the mother can give the surname of her second husband to the child after death of the biological father. The court made this observation while setting aside an order of the Andhra Pradesh High Court which directed a woman to include the name of her second husband in records as a stepfather. A bench of Justices Dinesh Maheshwari and Krishna Murari said that the direction of the High Court to include the name of the woman's second husband as a stepfather in documents is almost cruel and mindless of how it would impact the mental health and the self-esteem of the child. The bench said that there was nothing unusual in a mother upon remarriage having given the child the surname of her second husband or even giving the child an adoption to her husband. Being the only surviving natural guardian, the bench also wondered as to how the mother can be lawfully restrained from including the child in her new family and deciding the surname. The Supreme Court was dealing with a case between the mother who remarried after the death of her first husband and the parents of the deceased biological father of the child about the surname that should be given to the child. Opining on the importance of a surname, the court also pointed out that a child derives his identity from his surname and that a difference in name from his family would act as a constant reminder of the factum of adoption and expose the child to unnecessary questions, hindering a smooth, natural relationship between him and his parents. Referring to a prior case titled Geeta Hariharan and others versus Reserve Bank of India, the court noted that the mother has been elevated to an equal position as the father, thereby bolstering her right as a natural guardian of the minor child under Section 6 of the Hindu Minority and Adoption Act 1956. During the pendency of this case, the present husband had adopted the child by way of a registered adoption deed. Thus, referring to Section 12 of the Hindu Adoption and Maintenance Act and the definition given to adoption in the Encyclopedia of Religion and Ethics, the bench observed that while in the past the main object of adoption was to secure the performance of one's funeral rites and to preserve the continuance of one's lineage, however, in recent times, according to the modern adoption theory, adoption seeks to restore a family life to a child deprived of his or her biological family. Thank you. Let us know what your thoughts are on this verdict in the comments below. If you like our content, do not forget to like and subscribe.